Good day everyone. My name is Ryan J. Gumban, Bachelor of Science in Civil Engineering 3rd year. I am the first reporter in the Chapter 8 entitled Unenforceable Contract. In the article number 1403, the following contracts are unenforceable unless they are ratified. Number 1, those entered in the name of another person by one who has been given no authority or legal representation or who has acted beyond his power. Second, those that do not comply with the statute of frauds as set forth in this number. A. An agreement by its term is not to be performed within a year from the making thereof. B. A special promise to answer for the death, default, or miscarriage of another. C. An agreement made in consideration of marriage other than mutual promise to marry. D. An agreement for sales of goods, chattels, or things in auction at a price not less than 500 pesos, unless the buyer accept and receive parts of such goods and chattels, or the evidences or some of them such things in auction. E. An agreement for the leasing for a longer period than 1 year, or for the sale of real property or of an interest therein. F. Representation as to the credit of the third person. Number 3. Those where both parties are incapable of giving consent to a contract. So next is the meaning of an enforceable contract. So unenforceable contract are those that cannot be enforced in court or sued upon by reason of defects provided by law unless they are ratified according to law. Binding force of an enforceable contract. While rescissible and voidable contracts are valid and enforceable unless they are rescinded or annulled, unenforceable contracts, although valid, are unenforceable unless they are ratified. Next is the kinds of unenforceable contracts. Under the article number 1403, the following contracts are unenforceable. Number 1. Those entered in the name of another by one without acting exist of authority. Number 2. Those that do not comply with the statute of fraud. And the third is those where both parties are incapable of giving consent. A party to an enforceable contract may bring an action to enforce its subject to the defense of the lack of required form, or the absence of authority or in excess thereof. The law expressly provides that such contract cannot be assailed in the third person. Next is the meaning of unauthorized contract. Unauthorized contract are those entered in the name of another person by one who has been given no authority or legal representation, or who has acted beyond his power. The term statute of fraud is descriptive of statutes which required certain classes of contract to be in writing. This statute does not deprive the parties of the right to contract with respect to the matters therein involved, but merely regulates the formalities of the contract necessary to render it enforceable. The effect of non-compliance is simply that no action can provide unless the requirement is complied with. So next is the history. In the year 1677, the English Parliament enacted statutes to counter the evil practices of giving false testimony in action founded in certain kind of contracts. It attempted to deal with the prevalence of successful perjury by making specified contracts unenforceable unless evidenced in a prescribed manner. In general, by a written memorandum signed by the party against whom liability under the contract was sought to be enforced. Second, the purpose. The statute of fraud has been enacted not only to prevent fraud and perjury in the enforcement of obligation depending further evidence and the unassisted memory of witness, but also to guard against the mistakes of honest by men requiring certain agreements specified. This is written in the article number 1403. It must be in writing, signed by the party to be charged. Otherwise, they are unenforceable by action in court. Rosencore Development Corporation versus in Queen Sopra. Unless they be in writing, there may be no palpable evidence of the intention of the contracting parties, and the court must perforce rely upon no other evidence than the mere recollection or memory of witnesses, which is many times faulty and unreliable. Number 3, the application. Some fundamental principles related to the statute of frauds are given hereunder. A. The application of statute of frauds preposes the existence of perfected contract and requires only a note of memorandum to be executed in order to compel judicial enforcement thereof. B. The statute of fraud refers to a specific kind of transaction and cannot apply to many other transactions that is not enumerated therein. It is not applicable in actions which are neither for damages because of the violation of contract nor for the specific performance thereof. C. It is applicable only to executory contracts where no performance has as yet been made by both parties, and not to contract which are totally consummated or partially performed. The reason is that the partial performance, like the writing, furnishes reliable evidence of the intention of the parties or the existence of the contract. D. It is not applicable where the contract is admitted by the failure to deny specifically its existence, no further evidence thereof being required. E. It is not applicable where a writing does not express the true agreement of the parties. This is so because these statutes cannot be used as a shield for fraud or as a means for the perpetration of it. F. It does not declare that contract infringing it are void and of no effects but merely unenforceable. The form requires is for evidential purpose only. Letter G. It does not determine the credibility or weight of evidence but merely regulates the admissibility thereof. H. The defense of the statute of fraud is subjected to waiver. I. The defense of the statute of fraud is personal to the parties and cannot be interposed by stranger to the contract. Next is the illustrative cases. So here are some example. Example number 1, a verbal contract of sales of land is adduced to show the lawful possessions of applicants, entitling them to have their title thereto registered. The facts in here: X is presented evidence that they have been in possession of the parcel of land in question since the year 1912, when Y, before his death, delivered to them said land pursuant to a verbal contract of sale for the price of 1,500 pesos payable by installment, of which X had been paid to Y 500 pesos and later delivered to them the documents pertaining to the land. And that since their possessions and before then that of Y under a claim of ownership had been exclusive and continuous, they were entitled to have their titled over said parcel of land registered as applied for in the registering proceeding. Issue: May X introduce evidence of all alleged verbal contract of sales? Held is yes. The contract was not covered by the statute of fraud because the contract was partially executed. Furthermore, the verbal contracts was adduced not for the purpose of enforcing performance thereof, but as the basis of the lawful possession of applicants. Second is the verbal agreement sought to be enforced refers not to a sale but to a promise to convey a real property for services rendered. Here is the facts. In his complaint, X alleged as a cause of action that in the year 1952, the defendants availed themselves of his services as an intermediary with the deudors to work for the amicable settlement of civil case, and notwithstanding his having performed his services, as in fact a compromise agreement was entered into, the defendant had refused to convey to him the 3,000 square meter of land which the defendant had promised to do within 10 years from the signing of the agreement. In their motion to dismiss, the defendants allege that the alleged agreement about X services was unenforceable under the statute of fraud. There being nothing in writing about it, the trial court dismissed the complaint. Here is the issue. Is the statute of fraud is applicable? The held is no. It is elementary that the statute refers to a specific kind of transaction and that is cannot apply to any that is not enumerated therein. In the instance case, what is X is trying to enforce in the delivery to him of 3,000 square meters of land which he claims defendant promised to do in consideration of his services as mediator or intermediary in affecting or compromise of civil case between the defendant and the debtor.